Well, hello friends, and welcome to another WSIB Truth Matters with Joe Machado, where I separate the truth from bullshit, facts from fiction, in plain English. Last week in my last video, I indicated that I was going to be talking about contingency fees in my next video. So today's video, I'm going to go through the whole aspect of contingency fees, what it means, and what you need to be aware of when looking to sign one of those agreements. All right, my friends, so without any further delay, let's get at it. All right, so anyway, let's get into it. So what is a contingency fee agreement? In its simplest translation, it's an agreement that you have with a legal provider, whether it be a lawyer or a paralegal, whereby you agree to pay a percentage of any settlement that they're able to get for you when dealing with your WSIB claim. It also applies to Canada Pension Disability, ODSP, long-term disability, personal injury claims, and so on. And so basically, it means that when you sign that agreement with the legal provider, you agree that once there's a settlement that results from the actions that they're taking on your behalf, you agree to pay a percentage. That percentage should be stipulated on the agreement. It should be very clear. There should be no room for confusion, ambiguity. You should know exactly what percentage is that you're going to be paying. So let's assume that the percentage is 25%. And after the action or appeal or submissions have been made and that have resulted in overturning a decision and entitlements being paid, let's assume that it works out to $100,000 and your contingency fee agreement with your legal representative is 25%, then that's what you would owe, which means that it would equal to $25,000 using that $100,000 example. I've seen agreements, usually, in my experience, contingency fees are charged on arrears benefits. So in other words, let's assume that your loss of earnings benefits have been stopped for 3, 4, 5 months. And there was an appeal or there were a request for a reconsideration of that decision. And let's assume that that decision was overturned. So in other words, the WSIB, whether it be a case manager, appeals resolution officer, agreed to overturn that decision, then that money for the let's say 4 months that you had not been paid the loss of earnings, they would be obligated to pay that money. So let's use $10,000 as an example, and your contingency fee percentage in the agreement is 25%, then you would owe your paralegal or lawyer 25% of that money. I have seen lawyers and paralegals who charge upwards of that, significantly more. I've seen them charge anywhere from 35, 40%, and in some cases even higher. I don't agree with that, but it's their right to do it. They can charge whatever they want. And if you agree to it, then you would be obligated to pay that percentage once the case is settled or there are monies that are issued as a result of a decision. I've also seen it where lawyers or paralegals will charge a retainer or a deposit to to take on your case. And that can be a few $100s to several thousand. I suppose they do a risk assessment of what it's going to cost to handle the case, and make a determination as to how much of that they want to recover if they don't succeed in the case. So here's the thing. In my experience, and my firm, we started this back in the late 80s. That was actually the only company who started contingency fee agreements. At that point, and throughout the 90s, the Law Society did not allow lawyers or paralegals to charge on a contingency fee basis. That obviously has since changed. But if you're charging on a contingency fee agreement to get a percentage of what you're able to settle for the client, there's there's a certain amount of risk that you're taking. Because if the case has to go all the way up to the Workplace Safety and Insurance Appeals Tribunal, which would involve multiple appeals, it would involve preparation, it would involve transportation, attending the actual hearing. These are all costs that are incurred. And if essentially you are funding the case with the expectation that you're going to win for your client and you're going to receive a percentage, that percentage may or may not work out to far more than what you would earn if you had charged the client on an hourly basis. So that's somewhat of a trade-off. And the reason why contingency fees agreements are somewhat popular is because the worker doesn't have to worry about paying an hourly rate through the entire process and be on the hook for thousands and thousands of dollars whether they win or lose the case. And the trade-off is for the person taking on the case, the lawyer or paralegal, that upon winning the case, it could yield a considerably higher award than or earnings than if they had billed the person on an hourly basis. Some will charge a fee to get started or to assess your case. That's something that we do. And then help you determine whether or not it's even worth pursuing the case. And we do reject a lot of cases that we do not believe have merit. And people get pissed off with us, but it is what it is. We're not going to use our resources to fund a case that has no merit. And we don't want to string the person along by indicating that at the end of the day there may be a payout when in fact the likelihood is that it's not going to happen. So it's good to know that ahead of time, both for the worker and the person who's going to be handling your case. At the end of the day, there's no guarantees when you're dealing with the WSIB, Canada Pension Disability, a long-term insurer, Service Canada. There's no guarantees. Both parties will embark on this relationship with the expectation of a positive outcome. Now, some legal providers will charge for disbursements in addition to the what's stated on the percentage in the contingency fee agreement. Some will charge for travel. I have my own thoughts on that, but I generally don't agree with it. I think that a contingency fee agreement is based on if you win, you get paid. If you don't, you don't get paid. There are instances where it's worthwhile to get an expert medical report. It's referred to as an independent medical assessment or evaluation, where you're going to write a letter to a medical expert and specifically request certain types of information that would be helpful in the case. We always try to avoid that. We try to, we will write the letter in a very simple format, and then give it to our member so that they can take it to their doctor, so that the doctor knows what it is that they're looking for. And in most cases, the doctor won't charge anything for that. They may charge a nominal $50 fee if it's a large file that they have to do photocopying and all that kind of stuff, which I understand, but none of these thousands of dollars that normally would be sought by an independent medical assessor for their time. So we try to avoid that. In any event where we believe that it's absolutely necessary, that it would strengthen the case, then we advise the member, our member, and advise them that there's going to be a fee. What the fee is, you're not making money on it, you're just passing on the fee that'll be charged by the independent medical evaluator. And then the person will determine whether or not they would like to pay for that report. And that becomes their responsibility. But we do like to avoid it at all times if possible, because oftentimes if a doctor sees that a report is being requested by a third party, the tendency is that they believe that that third party is going to pay for the report, and the rate or the fee charged usually goes up significantly. Another thing that I've seen in the industry is where legal providers are charging a percentage of what the person is going to receive monthly until 65. In the form of a pre-1990 pension, of course, that would go for life. I've seen this trend over the past several years. I don't like it. I believe that once you've handled the case, LOE has been paid for any outstanding periods that were part of the argument, or an L award was granted for psychotraumatic disability, for example, as a result of your arguments, or organic impairment, or a personal care allowance, or if the personal care allowance has been increased, charging a percentage, and I've heard as high as 20% to 65. I think it's a bit much. Although, as I said before, each one will charge based on what they believe their services are worth, and it's always up to the worker, up to you, to decide whether or not you want to get that service. I've had people say to me, well, I got this service, he won, but he got a lot of money. What can I do to go and recover some of that money? Well, nothing. You can't do anything. You paid for a service that you requested. You're not going to go to a restaurant and order a steak or a surf and turf with a steak with lobster and the whole capuchabang and a really nice bottle of red wine and a cognac with an espresso to go afterwards and the dessert, and by the time you're done, you know, you're up to $200, and then you want the restaurant to refund you all or part of that money. That would be a bit silly. You made a decision based on having all of the available information in front of you, and then you need to abide by your agreement. And that's no different with lawyers and paralegals that you've hired to help you with your case. I can tell you, and I've seen this happen, where injured workers will get really pissed off about that they got the service, but they had to pay what they believe was too much after they were successful in getting their appeal won. Or at some point, they were told that, you know what, there really isn't a whole lot of merit moving forward. based on new information that's been looked at, a new evaluation and assessment of the case, or the person gets tired of waiting because they feel that their representative needs to be in contact with them every day or every other day, or respond to thousands of their endless questions, even though it's been explained many times. I think you can appreciate that lawyers and paralegals have broad caseloads, and that they need to do their due diligence to make sure that all of their clients and all of their cases are moving forward in a reasonable manner, and to pull all of their resources to manage one case, which some of the requests may be unreasonable. It's really not possible, and it's not fair to the other clients, and I don't think you would want that happening to you. So, but I've seen this, and then they'll go on social media and talk bad or badmouth that lawyer or paralegal and rake them over the coals and create all sorts of problems for them, and it's wrong, right? It really is wrong. If you don't like what the WSIB has done to you, if you don't like how they've treated you, how they've turned your life and made you feel this small, and you are pursuing your rights to get justice, these people that you've hired are doing the same. For you to turn around and do the same to them, which can affect their business, it's just wrong. It's ethically and it's morally wrong. And one of the things that I do frequently is, if somebody asks us for help, I will do, or we have a team that handles all of our social media marketing and marketing of our YouTube channel and all of these things, and they'll do some investigating for me. And if that person is found to have behaved in this manner, chances are we're not going to offer our help. That's pretty much guaranteed. I've been doing this for over 30 years, and I've dealt with all types. So the reason why I kind of segued into this is that when you make a decision to sign an agreement, knowing full well all of those factors, and decided that that was the best choice for you, it was the best option, so you wouldn't have to pay hourly to get those services, then whether you have issues during the process or after the process has been finished and it hasn't turned out exactly the way you want, then address it with the lawyer or paralegal. And if they don't address it properly, then you can go to the formal complaint with the Law Society, and which is the governing body for lawyers and paralegals, and they can do their own investigation. But to make them out to be a pariah or a scammer or whatever the case is in social media posts, which could really destroy their business and their reputation, that's wrong. And it can also open you up for significant liability for defamation. So just to caution you, read the agreement. If you have questions, ask your questions. I'm going to put a link here in the description of this video to the Law Society website and to the rules and regulations that govern contingency fee agreements. And if you want to know more about them, you can click that link, and there's a whole section on the Law Society website that covers that and goes into detail. Another thing that I've seen often, I get questions, or I see it on some of these social media posts as well. My lawyer charged me so much, or my paralegal, and I want to be able to recover these costs. Can I sue the WSIB, or can I sue the Tribunal to recover these costs? So the short answer is the WSIB or the tribunal have absolutely no authority to award legal costs. What that means is if you go to a hearing and at the end of the hearing you want to recover your legal costs for attending the hearing, the tribunal has no authority to award that. So it's not going to happen. The courts have much more latitude in this regard, and it's built into the court system where if you file a lawsuit and you're the plaintiff, or even if you're the defendant, your lawyers can request costs for the action, and generally costs can be awarded by the judge or the justice of the peace in a reasonable manner. So that pretty much covers the contingency agreement portion that I think it's important that most people know and understand. I may have left something out, I don't think so, but anyway, it's possible. If I have, the contingency fee linked to the Law Society will be able to go into more depth about some of the conditions and all that. I do want to talk about legal options though, because another thing is sometimes you have a member or you have a client who is totally unreasonable. They want your services, but they don't want to pay what you ask for your services. And you can't have it both ways. If I call an electrician to do work in my house and his fee is so much, that's the fee that he charges to do the work. If he agrees to pay a reduced rate, okay, he has, or for me to pay a reduced rate, he certainly has the authority to do that, and I certainly have the right to ask for a reduced rate. Once that's agreed upon, to expect that that person is going to work for free, return every call, review your file countless times, every time you have a question. These things can take hours. When everything's been done, the process is in motion, the arguments have been presented, the research has been done to present the arguments, all of that. To continue to request things and not expect to pay for it is unreasonable. So there are organizations that provide free service. It's the Office of the Worker Advisor. They've been around for years. I know that they have backlogs, but they do provide free service. If you're a member of a union, some unions, I think most, will have someone who will help you with your WSIB claim with varying levels of expertise. And those are generally free. But if you hire a lawyer or a paralegal, they are a fee for service. So if you decide that you want their service, then you can expect that they need to get paid for the service. I think I pretty much covered that. With what we do here at WSIB Settlements, we can do an evaluation or assessment to see if there's merit in the case and discuss that with you. And should an appeal be required, then the case is referred to one of our preferred legal providers, who are lawyers and paralegals who handle the types of cases that we will refer to them. Now, we try to get our lawyers and paralegals to give our members a preferred rate, and most do. And that may mean that they take on the case without any deposit or retainer, and that their fee is restricted to a percentage. So we do have this relationship with our lawyers and paralegals on our preferred legal provider network that I've talked about on some of my videos. One of the things that is very helpful to our members in terms of having that network is that we do a lot of the vetting for you. So in other words, we know the lawyers and paralegals that you're being referred to. We know their skill and experience level. And equally as important, we also do a search to determine that they are in good standing with the Law Society in terms of their membership with them. So this is all what we provide. All right, my friends, I hope I covered most of it. If you do have any questions that come up, by all means, send me an email and I'll respond to it. Okay, as always, it's been a pleasure spending this bit of time with you. I hope that I've given you something to think about. And coming up, as I also mentioned in my video last week, we will be doing a premiere. It looks like it's going to be next week, but be on the lookout because it has to do with the WSIB CEO and president and underlings accepting and condoning the falsification of documents. All right, my friends. So that'll be coming up. Stay on the lookout. In the meantime, and as always, take care.
We know that connecting with the right lawyer or paralegal to handle your case can be overwhelming. Do they have the expertise to handle your case? Do they have a good track record? Are they affordable? We've got you covered. Legal Pro Connect takes the guesswork out of finding the right legal provider. We've already done the vetting for you and connect you with the right lawyer or paralegal. With the expertise to handle your specific issue and at preferred rates. Get connected today. Visit www.wsibsettlements.com.